Please be seated. Make sure you're at the right place. We're Unit 2 today, or this moment of time, I should say. Half hour today.
This is Reno High School.
Yes. Make sure we're in the right place. Okay, let's introduce ourselves again. For everybody here, you've heard this before. I'm Dan Chase, and I'm an assistant United States attorney in Las Vegas.
My name is Jenny Bruchel. I'm an attorney at Holland & Hart in Las Vegas.
I'm Angela Leitner. I'm a criminal defense attorney up in Marina del Rey. I'm Rosa Silvestrini, and I'm an attorney at Morris Henderson here in Las Vegas with the Reno office.
And now what you're waiting for is what question have we selected? Number 3. And for your family and friends, here's the question for you. How does the Constitution balance state powers with powers granted to the national government? How does the Constitution limit each set of powers? What issues did the Philadelphia Convention leave unaddressed, and what have been the consequences of the failure to address them? You may begin.
Political scientist Herbert Crawley recognized that the Constitution crafted in Philadelphia was not comprehensive, but established an important relationship between the federal government and the states when he said, the combination of federalism and republicanism, which formed the substance of the system, did not constitute a progressive and formative political principle, but it pointed in the direction of a constructive formula. The Constitution balances state powers with powers granted to the national government by enumerating the national powers and leaving residual powers to the states.
Article 1, Section 8 outlines Congress's authority to lay and collect taxes, regulate commerce among the states, and raise and support armies. Article 1, Section 8, Clause 18 gives Congress powers necessary and proper to carry out its enumerated powers. Article 6, Clause 2 makes federal law supreme and limits state powers by declaring federal action the supreme law of the land.
In Article 1, Section 9, states retain their right to decide the time, place, and manner of elections. Article 1, Section 4 protects small states' power by guaranteeing them equal suffrage in the Senate. And Article 5 gives states the power to amend the Constitution by allowing them to propose a national convention and ratify possible amendments. Because anti-federalists felt the power tilted to the national government, the Bill of Rights was added, in which the states retain residual and concurrent powers in the 10th Amendment. For example, in Florida v. Department of Health and Human Service and National Federation of Independent Business v. Sebelius, the Supreme Court will hear arguments on the Affordable Care Act's potential violation of states' 10th Amendment reserved powers.
The Constitution limits federal power in Article 1, Section 9 by prohibiting the federal government from suspending habeas corpus absent domestic insurrection or invasion, or passing ex post facto laws or bills of attainder. Additionally, Article 1, Section 8 and the 10th Amendment limit the federal government to a specific set of powers and leave the rest to the states and the people. Congress has circumvented these limits through the Commerce Clause, but in 1995, the Supreme Court limited Congress's power under the Commerce Clause when it overturned the Gun-Free School Zone Act in U.S. v. Lopez.
To directly respond to the Articles of Confederation's failure, the Constitution limits states' powers in Article 1, Section 10, by prohibiting states from passing ex post facto laws or bills of attainder and from entering into alliances. The full faith and credit and privileges and immunities clauses in Article 4 also limit state power by declaring that all states must recognize both contracts and privileges and immunities that are granted in any single state. Because the Constitution did not fully ensure protection of individual rights, a need for a Bill of Rights was imminent.
The delegates never defined the scope of the necessary and proper clause. Brutus IX wrote the national government would ultimately subvert states' authority under the clause, but James Madison wrote in Federalist 44, without the substance of this power, the whole Constitution would be a dead letter. The court resolved this in McCulloch v. Maryland in 1819, ruling that Congress may do anything reasonably necessary to implement any power granted to any branch of the U.S. government.
Other unaddressed issues included slavery and state nullification of federal laws. In 1832, South Carolina passed the Ordinance of Nullification and declared the tariffs of 1828 and 1832 unconstitutional. The consequence of failing to resolve nullification in slavery was a heightened sense of sectionalism. The Philadelphia Convention also did not address the right for a state to secede from the nation.
The consequence for this omission was the secession crisis and the Civil War, also caused by sectionalism from the aforementioned nullification crisis. Secession was eventually ruled unconstitutional in Texas versus White. Though the Philadelphia Convention failed to address certain issues, it established an important balance of power between the federal government and the states. Thus, Supreme Court Justice Oliver Wendell Holmes best embodied the spirit of the Constitution when he referred to it as an experiment, as all life is an experiment. Thank you.
All right, follow-up questions for you. In what ways do the limitations on national and state governments protect individual rights?
Well, as you can see in the Bill of Rights, by enumerating these rights in the Constitution, it automatically gives the people these rights. Like, you cannot, the national government or the state governments can take these away because the Constitution is the supreme law of the land. And since we have these Bill of Rights, they have to abide by them.
Also, George Mason, who actually refused to sign the Constitution, partially because he felt that it gave the federal government too much power, said that there was no real declaration of individual rights, so therefore giving more powers to the states would make that more possible.
There are important limits on the state and national power placed in both Article 1, Section 9 and Article 1, Section 10. Article 1, Section 9 specifically prohibits the federal government from suspending the writ of habeas corpus or from passing bills of attainder or ex post facto laws which make someone guilty of a crime without trial by jury. So Article 1, Section 10 applies these limits to the state governments, and it says that likewise the states cannot suspend habeas corpus or cannot pass bills of attainder or ex post facto laws as well. So those protect individual rights because the right to a trial by jury and the right to know what you're being tried for under habeas corpus is an incredibly important and fundamental right that we've held ever since we came over from Britain.
Thank you. During your testimony, you discussed the various limitations on national and state government, and what I'd like to know is, in what ways do those limitations on national and state governments promote the common good of all citizens?
Well, the same limitations that we've just addressed promote the common good because the right to a trial by jury encompasses just more than the person being tried. This can be seen because you have a right to a jury of your peers of 12 members. Furthermore, knowing what you're being tried for is important for the common good because you have a right to a defense and you have a right to build a defense to that charge. And if you don't know what it is, then that's against the common good because then other people can't take the precedent established in your case and use it to apply, to their own selves and not break the same law that you did.
Well, also, states having the power to become sort of laboratories of democracy kind of gives them the chance to experiment with new policies and laws, which can also relate to their residents and their common good and what they believe would be right for them.
Another way that kind of helps promote the common good is with them, in Article 2 about the Electoral College, how we send representatives of the state to elect our president. So this is kind of allowing us to have our own population, kind of our own demographics, try to represent what we want and get that person that we want in office to be the best and help promote the common good for the whole entire nation.
This also falls under the idea of federalism because the states and the national government, in turn, they check each other. And so by checking each other through these various means, they are able to promote the common good for everyone, not just their own branches of government.
Something else that promotes the common good is the First Amendment. It says that Congress shall make no law that abridges freedom of speech or respects an establishment of religion. This allows the common good because people can speak their ideas for the common good and give input. Another important limitation is placed in Article 1, Section 10 says that the individual states cannot enter into alliances with foreign nations. Obviously, this protects the common good because if you allow states to start aligning themselves with foreign nations, you would have a huge amount of dissociation within the Union and we wouldn't be a cohesive governing body of the United States.
Thank you. What ideas are drawn from the natural rights philosophy what ideas drawn from the natural rights philosophy are reflected in the limitations placed on the state and national governments?
Well, natural rights philosophy, primarily advanced by John Locke, at its core said that the government must respect life, liberty, and property. So, two important limitations placed on government that follow that are the First Amendment, which protects your right to liberty to associate and to speak your mind, and the Fourth Amendment, which protects your right to privacy, says the government cannot institute an unreasonable search and seizure on your person without having probable cause and a warrant to do so.
Well, he referenced the First Amendment, but I would actually incorporate all 10 of the Bill of Rights. Because, as you can see during the Philadelphia Convention, many of the Federalists did not want a Bill of Rights because they thought that the states were adequately, and the people were adequately protected through, like, the writ of habeas corpus not being suspended and not being able to have bills of attainder. However, many of the anti-Federalists felt that without this Bill of Rights, the national government can circumvent these rights and not have that natural rights for the philosophy in their government.
Thank you. In following up on the electoral college and the common good of individual rights, 31 states currently require you to have a government-issued ID in order to vote. How do you feel about that?
I am completely against it because it kind of limits people who are poor. For example, driver's license, that's one of our main forms of ID, and that kind of limits people who can't afford to drive or who don't have that power. So it kind of goes against what the founders wanted, to everyone to have a voice, because in Great Britain, most of the people who had voices were the upper class, and the people in Parliament who inherited their seats from their ancestors.
What you've talked about is really at the heart of a current national debate. Legislatures like New Hampshire are currently talking about implementing these laws. And in addition to what Gabby said, I would say that something else that should be improved to help voter turnout and advance the common good is same-day registration, which a lot of states don't allow and which prohibits people from walking in and registering to vote and then voting on the same day. And the issue of promoting the common good by issuing those driver's license, proponents say, well, there's a lot of voter fraud that could happen if you don't have to show an ID. But that's proven false because cases of voter fraud are almost negligent. They almost don't exist. They've done studies that show that voter fraud is virtually non-existent if it exists at all. And so I think that requiring people to have government-issued ID is just an extra burden on them, as Gabby said.
Well, you can argue if you don't have that federal ID. You can also have people like illegal immigrants voting, which does promote the common good because they are a part of the society. However, they are not citizens, and thus they do not have the right to vote. So you can't, if you don't have a way to prove that you are a citizen and that you are capable of voting, it defeats the purpose in a way.
While we're talking about illegal immigrants, what are the major disagreements between the states and the national government today regarding powers to regulate immigration?
Well, states like Arizona and Alabama have strict immigration laws that have been controversial, but we also have to take into perspective that what's happening there and the immigration problem there is so much different from other states that don't necessarily have that problem.
The main disagreement, as Rick Perry has eloquently expressed, is whether or not the states or the federal government have the power to enforce immigration laws. And so what Gabby's talking about is an Arizona law that allows police officers to stop people and ask for their immigration papers. Another law in Alabama said that in order to attend public school, you have to prove that you're a citizen of the United States. So these are things that are at the heart of the federalism controversy, which is who has the power to make laws about immigration. The federal government would say that it does by virtue of the Commerce Clause in Article 1, Section 8, but this might not necessarily be true because one of the things that a law has to do to fall under the Commerce Clause is regulate the channels of commerce. And the channels of commerce between the states cannot go between another country in the United States, so that might be a power best left to the states.
And also another part about the Commerce Clause, we would look at about does it have reasonable relation to it. This is immigration. Before we talked about it in U.S. v. Lopez, and that was just about guns. But these are human beings that we're talking about, and as we have in the 14th Amendment, we have defined citizenship, and we're giving those people the right for them to vote, and so it's kind of more of a challenge, like as my colleague Nathaniel stated. It's a battle between the federal and the state governments.
just real quickly, a moment. Work into your answers now this concept of supremacy clause. You talked about immigration, other matters. How does supremacy clause affect all that?
Well, one of the most intriguing things about the Supremacy Clause says that the decisions of the national government are supreme law of the land, but also the decisions of the Supreme Court are the supreme law of the land. In Citizens United versus FEC, the Supreme Court ruled that people can make unlimited and anonymous donations to super political action committees. In Montana, the state Supreme Court recently upheld a law that goes against Citizens United and says that political action committees can't exist in Montana because they've had issues with the copper mines trying to control the legislature there. So this is an example of a state trying to buck the Supremacy Clause and saying, no, the federal government is not the supreme law of the land and we can decide that for ourselves.
Another check on that would be more like the 10th Amendment when they say all powers, not granted to the federal government is then go to the states. And this is kind of more of a state matter as we talked about interstate commerce just in the last question. It's more of a matter of,
I think what my colleague is trying to say with the supremacy clause, it's negated somewhat by the 10th Amendment because everything not enumerated by this clause, by Supreme Court legislation, it still gives so much more power to the states that hasn't been discussed yet. And that's what I think he was going to get with that.
Right.
Thank you. All right, some observations for you. Very good grasp of the historical and the current examples and understanding. Very good. And very good application of it. Let me start, though, to help you explain those a little bit by talking about your presentation. I want to have you just focus on the difference between your opening testimony of, was it 4 or 5 minutes, and your questions and answers. There was a difference in your pacing. When you were giving your initial testimony and you were reading it, you were going fast. And when you were going fast, what I found was I was missing it because I'm listening and I'm trying to, oh, you just said that. I think you've covered something else and you moved on and I haven't had a chance for that to absorb. Contrast that though when you were answering questions. You were pausing, you were collecting your thoughts a little bit, which gave me time to think through a little bit as well. So somehow, you have to take that skill that you've shown so well when you answered questions, of slowing down, pausing, and incorporate it into your first part of your presentation. How do you do that? Real simple. Practice what? Practice pausing. Speak in chunks or slow down, not slow down, you have to slow down your words, how fast. But when you come to a thought, stop a second. That'll let you prepare and allow me to chew on it a little bit. I'm sorry that my fellow judges have heard me speak this before, but can I give you an example of how to remember pausing? And we do it all the time when we're in a ceremony like today. Are you ready? I pledge allegiance to the flag of the United States of America, as opposed to, I pledge allegiance to the flag of the United States of America. We have a natural pausing or breaking in chunks. We don't pause at the end of the sentences. We pause it, phrase it in chunks. So work on it. Okay, now, well, that's enough. You'll cover the rest of the thoughts. Very good.
No, I think that was a great point. I mean, it's something, speaking fast is something I still need to work on every time. So honestly, hearing that 5 times today is great. So it is something to think about. Your presentation was excellent. I agree. The question and answer was so good. I was just listening. You guys had great thoughts. What I liked is you give an example. Well, you'd even say what the question was, explain what the question meant. You'd give the example, and then you'd explain how your example came back to the Constitution. And what you also did is, what I really liked is you gave both sides of the story. I mean, you might think one way or the other on some of these issues, some of these, with voting and immigration, but you gave the other side, and you even went further sometimes, is when you gave perhaps like a counter argument, you gave reasons why maybe that counter argument wasn't wasn't good or were facts against it. You know, you really kind of developed these arguments. It was very impressive. I really just enjoyed listening to you because you all just played off each other. You finished each other's sentences. When someone, you know, you had a pause and someone continued on, that's fantastic. It shows that, A, you understand the issues, you understand the Constitution and how they're relating to these modern issues, but also that you're listening to each other and you're really building off each other, and that's fantastic. And so it was excellent. The question and answer was excellent. And your presentation at the beginning was also excellent. You know, maybe a little fast, and I think it's just because you have so much to say. And that's good. I want to hear it all. Just, you know, like you said, the pauses would just take that to the next level. So thank you. It was very good.
I literally adopt everything she just said. I actually wrote listening well to each other. I mean, I can't say anything better than she really did. It was nice because you would start, at least with your cross-ex, you would start with an idea, and you kind of stopped, and I was like, oh man, are they not going to continue? But then boom, another one of you just starts talking, and you get into the topic, and you're telling me why your colleague or your partner just started there, and it was like, oh wow, great, we can talk some more. And I appreciated that, and you are listening to each other, which I think is amazing, because I know you guys probably have 5 million things going on in your head. So the fact that you are even paying attention and you guys are on top of this and know what's going on is we acknowledge it, we see it. It's not lost on us, so good job on that. As for your testimony, I really liked, you talked about the Civil War. I mean, I haven't heard that one yet, so that was great. It was something new for me to hear, which I always appreciate, especially as we get going on in the day. But what I really liked about your testimony was how you ended it. I liked how you ended it. You said, even though there's some things that weren't addressed, that it basically provided a good roadmap for the future. I was like, oh yeah. And I liked how you ended that, and you tied everything back together, that even though, yeah, we can't address everything all at once, because we don't know what's going to happen. And the fact that it's providing that roadmap is what we do on a daily basis in the legal field. And it was just nice to hear it and that you guys understand that concept. Good job.
I won't repeat all the great comments that have been made. I mean, I think you guys have fabulous presence, and you have a great voice. And, you know, you were all very articulate in presenting your ideas. And I agree that I thought you were strongest in your question and answer because you were kind of adding on additional information that you've learned maybe either independently of each other or, you know, that maybe appealed to you more so than somebody else. And you all built on the concept while still adding new ideas and such. With respect to your testimony, I don't have any problem with notes, and it might have just been me personally, but I don't like the barrier. You know, holding the things up felt like you were using it as a shield from us. So although, like I said, we've had several groups and stuff that use notes, and there's nothing wrong with that. I don't know how you guys, I mean, you can weigh in, but just as you go further in the competition, I just think you might be better off like laying them on your desk, you know, on the desk in front of you or on the table instead of holding them up like in front of yourself. But you have, I mean, I think you have the capacity to take this, and you guys did great. I didn't see that anything, but.
I agree with the notebooks. It was a little distracting at first. I got over it, of course, but it's distracting at first, so, you know, it'd be helpful.
Thank you.
Okay.